I'm sorry. Was the court going to indicate something?
No.
Okay, I thought.
Want me to?
No, I thought I was
I can
interrupting
say
something.
if you want me to.
I apologize.
That's the first time ever you stopped. Something to say. Go ahead, Ms. Finley.
Just trying to read the room for once. Your Honor, we did review the pre-sentence report together.
Defendant.
Your Honor, Alexander, on behalf of the people, Your Honor, the people would waive any potential conflict between this honorable court and the Office of the Public Defender. While the people don't believe such a conflict exists, the people make this waiver.
Spirit.
Good afternoon. This is the Public Defender Warren, Public Defender's Office. Likewise, the conflict exists, but if one does, we also believe.
The court, for its part, also does not believe there's a conflict either in Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matter. Court does call the case of the people versus Christopher Coyle.
Alexander, on behalf of the people.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Coyle. Mr. Coyle, state your name for the record, please.
My name is Christopher Coyle.
Your Honor, we did review the pre-sentence report. I did provide Mr. Coyle with a copy. I believe at this time we don't have any material changes or additions to that. We do ask that you adopt the recommendation.
And Teresa Clare on behalf of probation. Your Honor, the victim in the case, Zelie Everts, is present. She would like to address it.
Oh, good. We're there.
Riley sitting with the glasses, then I'll sit next to you.
She asked to lift the order. The judge listened, then added more probation, jail time, and strict conditions.
Your Honor, the name is Zelie.
I'm sorry.
Her name is Zelie.
Zelie Everts.
Can I just say my name? Zelie Everts.
Yes, ma'am. What would you like to tell me?
I'm here to lift the no protection order, or is that what I'm not really too, I just know I want to lift the court order for like the protection.
So the court order, which indicates no contact.
Yes.
Is that what you're looking to have removed?
Yes.
Okay.
That's what I am.
And is there a reason why you want me to lift that?
We have a lot of bills shared, and I feel like that's, and also we gotta talk about everything because, you know, a lot of things have happened, so we weren't really able to talk about things, as well as we're engaged, so we would have to figure out that as well. So.
Got it. Okay. And you're not in any fear of him? Are you in any fear of him?
Oh, no.
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 Not at all? All right. Anything else you want to tell me?
No, thank you.
All right. Thank you.
Okay, so we have a seat.
And Your Honor, I did speak with Mr. Coyle about the possibility of lifting the no contact order. We have no objection to that if the court so chooses. I will add that Mr. Coyle did speak to Ms. Plara and myself about the possibility of moving to live with his parents in Florida. His parents have lived there now for a couple of years. Is that what you said?
They've been there since July
Okay.
of this year.
Mr. Coyle is homeless here. Obviously, his parents would be able to support him down in Florida. So he did want to present that possibility to the court as well.
And Teresa Clare, on behalf of probation again, Your Honor, I did want to make the court aware there was a bond violation in this case where Mr. Coyle did go or had contact with the victim while there was a no contact in place. Probation originally had an 18-month for a deferred recommendation. Probation has upped that to 24 months and also was requesting a GPS tether, given that there is a no contact order currently. If the court changes the contact from Ms. Everett's request today, then the GPS tether on the recommendation.
Mr. Coyle, is there anything you want to tell the court before I impose sentence?
I regret everything that I have done. I have full remorse.
I'm sorry.
I said I have full remorse of what I have done.
And Ms. Blair, you're indicating that with reference to that bond violation, you've taken that into account in terms of the sentence.
Yes, I did,
Okay.
Your Honor. I originally had recommended, when I spoke with Mr. Coyle during the PSI, I did indicate to him that I was recommending an 18-month for a deferred, given he has no prior arrest or conviction. Given that there was that bond violation, my recommendation to this court has changed.
All right. Sentence of the court, 24 months deferred sentence pursuant to section 7694A of the Spouse Abuse Act. You are to pay $555 fines and court costs, $720 probation oversight fees. Do you know when you may be able to pay that?
I have to, my parents are willing to pay for that, so whenever I can pay for it.
What I will indicate is that's to be paid within 30 days after release. There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete a domestic violence program as directed by probation. There is to be, I will lift the no contact provision. I'll indicate no non-consensual contact was the efforts. You understand that, sir?
Yes.
You understand what that means?
Yes.
All right. I'm going to strike, given my change to number 6, I'm going to strike number 7. There is to be no, you are not to assault, terrorize, frighten, intimidate, threaten, harass, molest, or stalk anyone. You are not to possess any weapons, firearms, ammunition, or anything fashioned to be a weapon. You're to comply with any and all circuit court orders, if any. I will not place the defendant on a GPS tether, given the change in the condition in number 6. I'll set a review hearing on this matter to be held February 9th, 2026 at 1 p.m. I will order 93 days in jail, credit 11. The balance is suspended. With reference to any move to Florida, he'll have to give details to probation, and then we'll make a consideration regarding it.
Thank you, Your Honor.
Thank you, Your Honor.
Pardon?
The next individual is.
Remorse was shown. The order was lifted, but the sentence still came down hard.
Court does call the case of People versus Kyle Wilson.
Alexander on behalf of the people.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Wilson. Mr. Wilson, please state your name for the record.
Kyle Wilson.
Your Honor, we did review the pre-sentence report. I'm sorry, was the court going to indicate something?
No.
Okay, I thought,
Want me to?
no, I thought I was
I mean, I can
interrupting
say
something.
if you want me to.
I apologize.
That's the first time ever you stopped me. Something to say. Go ahead, Ms. Payne.
Just trying to read the room for once. Your Honor, we did review the pre-sentence report together. We don't have any material changes, additions, or deletions. I also reviewed the sentence recommendation with my client, and we ask that you adopt it.
Your Honor, may we approach?
Yes, you may. I was actually going to ask that you.
What we just witnessed is a textbook example of how courtroom outcomes are shaped not just by emotion, but by structure, history, and credibility. On the surface, this might look like a moment of reconciliation. A victim standing before the court, clearly composed, clearly voluntary, and asking for the no-contact order to be lifted. She explains shared bills, an engagement, unfinished conversations, and most importantly, tells the judge she is not afraid. Those details matter, and the court listens carefully. But listening does not mean surrendering control. Judges are tasked with protecting not only the individuals in front of them, but the integrity of the judicial process itself, and that's where this case becomes instructive. The probation officer's statement changes everything. Despite the request to lift the order, the court is reminded that there was already a bond violation. Contact occurred when it was explicitly prohibited. That single fact reshapes the entire legal posture of the case. Legally, a bond violation is not a minor misstep. It signals non-compliance at the earliest and most critical stage of court supervision. That's why you hear probation adjust its recommendation from 18 months to 24 months deferred. It's not punitive emotion, it's procedural consequence. Courts rely heavily on compliance as a predictor of future behavior, and when a defendant violates conditions before sentencing is even complete, it raises red flags regardless of intent or reconciliation. Now, notice how the judge navigates this. The no contact order is lifted, but not entirely. It becomes no non-consensual contact. That language is deliberate. It protects the victim's autonomy while preserving a clear boundary. At the same time, the judge declines to impose a GPS tether. Why? Because the conditions changed and tethering is meant to enforce distance. Once distance is no longer legally required, surveillance becomes excessive rather than corrective. But leniency ends there. The sentence still includes 24 months deferred, financial penalties, substance restrictions, random testing, a domestic violence program, and a suspended jail sentence of 93 days with credit for time served. This is the court saying, I believe remorse, but remorse does not erase responsibility. Deferred sentencing is not freedom, it's probation with a warning label. One violation and that suspended time can become very real. Another important layer here is the proposed move to Florida. The court doesn't deny it outright, but it doesn't approve it either. Instead, it places the burden on probation review. That's another example of judicial restraint. The judge keeps oversight local while allowing flexibility if accountability can be maintained. This case highlights a critical lesson for defendants. Cooperation and remorse can influence how a sentence is structured, but they rarely eliminate consequences entirely, especially after a violation. And for victims, it shows that the court will respect your voice while still exercising independent judgment about safety and compliance. So here's the question for you. Did the judge strike the right balance here? Was lifting the order appropriate given the bond violation, or should stricter controls have remained in place? Let us know what you think, because cases like this live in the gray area where law, emotion, and human relationships collide. And if you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.